So, Mr. Mojica, what was the dog barking? Is that why you shot it? Because you two were arguing. Was the dog barking? Like, I just don't understand why you shot the dog.
No, he was just the dog. It was just a gift I gave to her, and I was mad at the moment. I was like, I
The
was
dog was
hurt.
in the crate, wasn't barking, nothing, and she went into another room and you shot the dog.
Yeah.
And why did your mother hit your girlfriend?
In that moment, that happened outside. I wasn't, that's where she went outside. I stood in the house. I was by myself in the living room.
I know, we're moving on from the dog. Now the police are called, your mother was there during this whole thing, and you guys go outside, and she says to your girlfriend that, I've been waiting to do this, and then she punches her in the face. I'm trying to figure out why.
Because I put my mom in that predicament too, and I lied to my mom.
You lied and told her what? That she was cheating?
Yeah.
And that's not all, ladies and gentlemen. To add insult to injury, this woman, whose dog he shot and whose life she wrecked, actually wants him back home so she can have him to help with their child. Now it's up to the parole board to make sure that that doesn't happen. But this is the Connecticut parole board, the ones that wear those rainbow glasses, the ones that try to release all felons back into the streets. But perhaps this time, perhaps the idea that dog sitting in the crate because he was pissed off, maybe for once we will actually see a denial. There's one thing that I think us Americans can agree on, and that is shooting a dog is not okay. Now, let's see what happens. With that, let's jump in.
Good morning, I'm Panelmember Barry.
Good morning.
Joy Chance.
Good morning, Panelmember Rodriguez.
Please state your name and inmate number for the record.
Melvin Mojica Cruz, 426432.
Is hearing is being conducted in consideration for a broad application from Melvin Mojica, 426-432. He is serving a sentence of 10-year execution suspended after 4 years with 5 years of probation for criminal possession of a firearm. As of today, record from public eligibility date of September 7th, 2026, there is no taking of this case. There is an offender accountability plan for this offender. It has been reviewed and shows the offender has completed the following programs: smart recovery, domestic violence tier 2, utilizing the statewide collaborative offender risk evaluation system scores. The offender's overall score for recidivity rating falls in the high range. This is your opportunity to express to the board why you believe you should be granted parole. You may begin.
I got a letter. Can I read my letter?
Yes, thank you.
Good morning. Thank you for giving me the opportunity to be here today. I would like to begin by expressing my remorse and by taking full accountability of my action. I had the time to reflect deeply on my choices. I would like to apologize to everyone who has been affected by the crime I've committed, especially my son's moms. I have taken the initiative by utilizing my time, rehabilitating myself, and becoming a better person. I have participated and successfully completed the following program provided by DOC. Tier 2, domestic violence, smart recovery, AA, and NA. Each of these gave me insight of things of important value. Domestic violence has taught me about triggering situations that can arise and how to problem solve and make better decisions. Tier 2 and smart recovery has taught me about my addicted thinking pattern, relapse prevention strategies, accountability, and awareness. Also introduced me to NA and NA. I learned structure and how to live in life's term. AA and NA told me that I'm not alone in my recovery, that these are others out there that are willing to help me. My plan is to keep attending to school. I started college while being incarcerated in business. So I could become a better father to my kids. With all of this knowledge, I came to understanding that respect for others, for the law, and myself. I would like also to add that upon my release, I have employment construction with my stepdad. I will be working a minimum of 40 hours a week, full-time employment. I will be working there while I work towards my barbering goals. Now I live a productive life, contribute positive to my community, and to never repeat the same mistake that brought me here. Thank you.
Thank you very much, Mr. Mujica Cruz, for that statement. We appreciate the information that you shared. We have a few more questions for you after reviewing your file. Mr. Rodriguez, we'll start with questions.
Thank you, Madam Chair. Obviously, your charges are very serious, Mr. Mojica, right?
Yes.
Prefer Mr. Cruz or Mr. Mojica Cruz?
Mujica, if
Mujica.
it is here for you, yeah.
Okay. Yeah, I mean, yeah, and the thing that really got me is that you fired the weapon, you shot the dog?
Yeah.
Well, I didn't understand that.
Yeah, that day I went through by my emotion. Like, yeah, it was my choice, and I regret that to this day. I affect a lot of people, I affect my family, and I regret it.
Were you high?
Yeah.
What were you doing? What drugs were you doing?
I was doing Percocet and I was doing the weed.
Man, what were you doing with a gun?
I was trying to be somebody I wasn't. I don't got no excuse for that for a gun. So I just was trying to be someone that I ain't, that's not me.
You weren't supposed to have a gun.
I know.
You don't have a license for a gun, right?
No.
You don't go to target practice with a gun.
No.
Yeah. You know, so you probably barely knew how to use the gun.
Yeah, it's true.
Good news for you. The good news for you on my end is that that you took some programming.
Yeah.
That's positive. That's positive on my end. But also, having taken the programming, this year you got a ticket.
Yeah.
March you got a ticket. March you got a ticket. In June of 25 you got a ticket. 2 tickets in June of 25. And then what exactly did you learn from this experience? You took DV in January, it looks like, finished it.
Mm-hmm.
But in March, you get the ticket.
Yeah, it was the ticket. It was something I could avoid, and it's all about me that I could avoid the success that happened. And yeah, it's something a mistake that I'm learning.
Now, I get it was a mistake that you learned from. It's just, it's hard to understand. You get, that kind of work done in terms of a program, and you don't use what you just talked about, having learned about your triggers.
Yeah,
But you didn't utilize what you learned about your triggers to set you off for the ticket.
Yeah, it's true.
Right?
It's yeah.
I mean, from our end, we have to figure out that you're ready and suitable to be released, and that when you're released, the community, and I'm assuming not the animals in the community, are going to be safe from you.
Yeah. I learned from this business. I learned a lot. And when I'm being incarcerated, that I work in my emotion. I work in I work a lot in my emotion and my body.
What's the work that you're doing on your emotion?
Emotions. I learned that I got it. I got it in my emotion. I learned a lot that I can let them get out in a bad way. I'm trying to think positive. That's why I was doing positive thing until that day that with the ticket.
You took tier 2, right? But I think I read that you were removed from tier 4. Why? It would seem to me that would be a really good program for you to have taken and completed.
Yeah, I volunteered for that program, but I talked to the CO that run the program, the counselor, And that's why they removed me, and I still was doing smart recovery.
Well, it says you failed to comply. That's why you were removed. Not because you asked to be removed.
No, I didn't ask. It was, I wasn't doing what I was supposed to.
You weren't doing what you're supposed to be doing.
And it wasn't a bad way. It was like, I wasn't doing the program at that moment. I mean, I wasn't doing the program.
Well, it's not a good way if you're failing to comply. That's not a good way, right?
Yeah, but I think that's why they let me still be in smart recovery.
You were removed from Second Chance too. Why were you removed from Second Chance?
I never made it to Second Chance program.
Was that the DR?
No, no. It was they came and do the interview, but they never like told me nothing else.
Okay, that's not what I had. But
yeah, I never was in I applied for Second Chance, but they never after that interview they never got back at me.
I mean, I have to be honest with you, the DR has really, threw me off in this, especially the recent one.
Yeah,
Because we really like to see that when we're thinking about suitability, we want to see somebody that's been able to comply with what's going on where they're at. You don't have an extensive criminal record, but you do have 2 situations of community release that you didn't make it through. Which probably tells me you didn't utilize the help that you could have utilized at that point.
yeah.
I'm not sure. I'll be honest with you. I do have some concerns, with what I've read. And I do hear that you've taken some programming, and I hear you learned about your triggers. But the recent DRs kind of set me back a little bit. So I'm going to pass it on to my colleagues and hear what they have to say about this. See how you respond. But I mean, I want you to know that I am concerned about it.
Okay. Thank you.
All right.
Yeah.
I hope that whatever happens today, that you figure out how you're going to be able to take what you've learned and really be able to utilize this. You're not getting any more tickets.
Okay.
All right. Thank you.
Thank you, Mr. Rodriguez. Ms. Chance?
Why did you have a gun, Mr. Mojica?
Well, can you repeat it again?
Why did you have a gun?
I was a little bit more younger than now, and I was I don't got no excuse for that. That's I don't got no excuse for why I was having a gun. I can't.
So you were angry. Was your intention to shoot your girlfriend and just decided to shoot her dog at the last minute?
No, that wasn't my intention.
Why did you shoot the dog?
Like I said at the beginning, it was my emotion. I was on the wrong all of the time. I was the one that put myself in that position. I was cheating on her. I was doing things that I wasn't supposed to be doing, and I put myself in that position.
And then you got mad because you thought she was cheating on you.
Yeah, and yeah.
Was there a young child present when you shot the dog?
My young child was in the room.
How old was the child?
He was 2.
Yeah. I have to tell you, Ms. Mojica, your charge is a pretty serious one for me. You were in possession of a gun. You had no license for the gun. You probably don't know how to use a gun properly.
I really didn't know.
Right. And you go there angry and you're confronting someone with a child and a dog. What would have happened if you shot her or the child?
It never was my intention to shoot at her or my son. But by like I'm saying, by emotion, that was a mistake that I chose to do.
Then you have 6 disciplinary reports, and my colleague pointed out the timing of some of them. It would have been helpful if you had done the tier 4, but my understanding is that you were not complying with the requirements of tier 4. And I know when you were in the community before in 2017, you did complete a treatment program.
Yes.
So it's not as if you don't know what you need to do. And here you have an opportunity, as my colleague pointed out, to take one of the best programs and you screw up. So you're in tier 2.
Yeah, I did tier 2 first, then I applied for tier 4.
So your actions are quite serious for me, Mr. Mahiga. And it's just extremely concerning that you would go there angry with a gun.
I think because what I've been through in this 20 months that I've been in jail, I think I'm not gonna put myself no more in that predicament. Because I learned a lot, and if I want to talk about I hurt my whole family. I broke up my family. I broke up my relationship with her, and all of it was because of me. And I know I made mistakes while I was in jail. That I caught the tickets, the DR. That was me. But I think I could be able to, if I get the chance, I think I could be able to fix what y'all see in paper about me.
Okay, and you were on probation.
Yeah, I was on
And
probation.
you did all of this in
Yeah.
possession of the gun, shooting the dog.
Mm-hmm. Yes.
So you had no concerns about being on probation and doing stuff that you weren't supposed to be doing?
No.
Were you employed? Were you working?
Yes. I'm a barber.
Legitimate job?
Yeah, I had 2 jobs. Town Fair Tire in East Haven, and I was in the barber shop.
And you were paying taxes and being
Say it again.
you were paying taxes, you were paid on the books?
Yeah. On Town Fair Tire, I was getting paid, and I was paying taxes. In the barber shop, because I was on my process to go to Millennium School in Bridgeport of barbershop, I was a beginner barber, so I was just practicing and in the barbershop.
Well, do you think that you've learned anything from any of the programs that you've completed that you didn't know before?
Yeah, I never been to like NA or AA, and it showed me a lot. It showed me that if I need some help, I could ask for them. Everything that I was doing before this incarceration, and I was trying to fix everything. I know I had some problem, so if I would have asked for help, I would have do better. So I still go to Smart Recovery, and I graduated, but I still go because it helped me. It made me think about my boundaries. I got to think more about my surroundings. So it helped me. Smart Recovery is helping me more.
Okay. And what are some of the things that you're taking away from Smart Recovery?
How to communicate more, how to fix my problem by talking, and doing positive things.
Okay, well, that seems reasonable. And you did complete domestic violence.
Yeah.
So what was your takeaway with domestic violence?
what I learned in domestic is that I wasn't hurt. I heard everybody is a victim, and I hurt my girl by putting in that predicament. I hurt my son by me getting incarcerated because my choices. And I learned too that I could fix my problem by talking, not by arguing, not by screaming, not by fighting. I learned in domestic.
The other thing is, Mr. Mojica, you indicated that you were cheating on your girlfriend, so that doesn't bode well for you as a young man. You have to have good values too, right?
Yes. And I learned that because I don't want to do what I don't like to the person. I don't want to do what I don't like they're gonna do to me. So I know if I get in the future, if I get to a relationship, I know how to treat a woman. I wasn't capable to do that with her.
Okay. All right. Well, thank you for sharing and answering my questions.
You're welcome.
Thank you, Ms. Chance. So, Mr. Mojica, what was the dog barking? Is that why you shot it? Because you two were arguing. Was the dog barking? Like, I just don't understand why you shot the dog.
No, the dog. It was just a gift I gave to her, and I was mad at the moment. I was like, I
The
was
dog was
hurt.
in the crate, wasn't barking, nothing, and she went into another room and you shot the dog.
Yeah.
And why did your mother hit your girlfriend?
In that moment, that happened outside. I wasn't, that's where she went outside. I stood in the house. I was by myself in the living room.
I know, we're moving on from the dog. Now, the police are called, your mother was there during this whole thing, and you guys go outside, and she says to your girlfriend that, I've been waiting to do this, and then she punches her in the face. I'm trying to figure out why.
Because I put my mom in that predicament too, and I lied to my mom.
You lied and told her what? That she was cheating?
Yeah.
And then you also received an intoxication ticket on April 16th of last year. What were you using?
Oh, I was K2 and on Suboxone.
Wow. Okay. Give us a few minutes to talk about your case, Mr. Mojica. We'll give you our decision shortly. Mr. Rodriguez?
Thank you, Madam Chair. Look, Mr. Mojica has taken some programming. But for me, some of the programming just hasn't stuck with him yet. You just mentioned the intox ticket on April the 16th. He finished here too, April 1st.
Of what year?
Of that year,
Oh.
25. Same year.
Wow.
So, I mean, he took DV, which he said to us, created some, if I understand, it's triggers.
Mm-hmm.
Yet he had the issue with the officer where he kind of said some really nasty things to the officer that weren't very nice, right? We have a situation where he violently used a weapon. He shoot the person, but he shot an animal in a cage.
Yeah.
That wasn't even
Doing
threatening
anything,
him. Wasn't even threatening him.
But I failed to mention while I was speaking with him that he violated his probation for the second time with a weapon.
Correct.
Exactly.
Correct. And I think he understands it's hard to have him suitable for discretion parole today. I'm not there.
Yeah.
Would I consider he doesn't get out to 2028. He's got EOS to 20. I would consider a rehear, possibly maybe an anger management course. I don't know what happened with the TV course, but if you take maybe you could take an anger management course to kind of figure out where some of that anger is coming from. But that would be something I would be happy to consider. You guys, I'm definitely not discretion parole today.
Okay, thank you.
I'm not there. Rodriguez says.
So you are willing to have a rehear because I did not.
I didn't have a read.
I just think that the seriousness of this crime is very concerning when you start killing animals.
very concerned because I'm wondering, what if it wasn't the dog? The little baby was there.
It was a ricochet.
The woman was there,
And the mother, and
and the mother was there.
And the victim wrote a letter in support of his being released early. She said that she needs the help with their son.
Right.
But my concern is that the whole thing, the whole dynamic, is sounds very toxic. I haven't denied his criminal history is concerning, his poor institutional adjustment. He was on probation, the nature of the crime. We can go down the list, but I don't have him returning.
I didn't.
Yeah, I did, but coming back in a year, but
Okay, so what reasons for your denial?
I'm saying nature and circumstances of arrest, current offense criminal on probation, poor institutional adjustment.
Okay, those are, I think that those are fine.
Yeah.
Do you have any future admin chance?
No.
Okay.
Later.
So with regard to Melvin Muheka Cruz, I move to deny discretionary parole based on your poor institutional adjustment, the 6 disciplinary infractions, the nature of your crime, which we've discussed at length, and your offense was committed while you were on probation. Is there a second?
Second.
All in favor? Aye. All right, so Mr. Cruz, Mr. Muheka, you will not receive a new hearing. You'll receive this in writing shortly, though. Good luck to you, sir.
Thank you.
And this, ladies and gentlemen, is proof that the parole board has it in them. I told you, we knew it. We knew it was deep down there, but only when it comes to a dog. And isn't that fascinating? Little children, they don't care. Our kids, what's the big deal? But a dog, that's where they draw the line. They won't even give a rehearing. And I bring this up not just to salute them, but also to mock them, because it is insane that we will see this time and time again, over and over, with a survivor in the room pleading, saying, parole board, please wait until I graduate high school until you release this monster. And they will talk themselves into a rehearing. They will talk themselves into granting. But a dog, that's where they draw the line. Now we're about to watch another hearing that paints exactly this picture. So buckle up and jump in.
But you're not attracted to minors, right?
I mean, not like all the stuff they talked about it. I don't really feel like identified with that.
Okay, right. That's what I'm saying. So it's not a specific type of person. It's just you just wanted to have sex, and you keep saying that you've learned how to manage that. But what do you do to manage that? Do you work out? Do you listen to music? Do you go for a walk? Like, what kinds of things? How do you handle that?
But handle what? Like,
Your desire to have sex with just anyone.
Your desire to do it with just about anyone. And that just about anyone was his biological 8-year-old sister. And he was 18 years old at the time. But what's crazy about this hearing is that the parole board is going to attempt to paint a picture that he is not a chomo, that he has no interest in little ones, none at all. But in fact, he was just curious. He just wanted to know what it was like. Yes, he had a girlfriend, but she didn't want to know what it was like. So he had to find out. And the parole board is going to push that agenda on him and make him answer, yes, that is true. This is one of the most insane hearings that we have covered. And this is just the beginning of it. So with that, let's jump in.
Manuel Chingo Cooks, 440051.
This hearing is being conducted in consideration of the parole application for Manuel Chingo Cooks, inmate number 440051. He is serving a total effective sentence of 20 years, execution suspended after 5 years served, followed by 20 years of probation for sex 1 and illegal sexual contact. As of today, record reflect the parole eligibility date of July 29, 2026. There is no victim input in this case. There is an offender accountability plan for the offender. It has been reviewed and shows the offender has completed the PSB short track, tier 2, and unlock rate. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score falls within the moderate range of risk for recidivism. Utilizing the static 99R, the offender's overall score for sexual offense recidivism falls within the low to moderate range. Mr. Chingo Cooks, this is your opportunity to express to the board why you believe you should be granted parole. You may begin.
First, I want to say I'm sorry for what I did, and I regret it. And I wish I could change it, but I was like, I accept it, and being here, I have learned a lot of stuff, and I feel like I deserve this, but I think I also deserve a chance to get out. That's it.
Okay. Thank you, Mr. Chingo Cox. We will be asking you some questions and then we'll deliberate and give you our decision. Okay?
Yeah.
Okay, and Ms. Berry will begin with questions.
Thank you, Madam Chair. Mr. Chingo Cooks, is it okay if I just call you Mr. Cooks?
Yeah.
Thank you. So I heard you accept responsibility for your actions, and I also heard you say that you are ashamed of what you did. What is it exactly that you did?
How the underage girl.
And that underage girl was related to you, right?
Yeah.
And how has this crime impacted your family?
Has impacted them a lot, like, and it impacted them, like my whole family, because
How?
they went through they have to deal with like all this stress, and like I know they care about my sister, and they also care about me. So
Right. And have they forgiven you?
yeah,
And how about your sister?
she did too.
And do you know why you did this?
Yeah, I think so. Yeah.
Okay, tell us why.
I think because when I was young, I was introduced to pornography, like very young, and when I grew up, I just started watching it too, and I think I was kind of like obsessed with sex, and I just kind of like wanted to have sex with somebody.
So that you didn't have a girlfriend at that time that you could have, I mean, being preoccupied by sex at age 18, I don't think that that's an abnormal thing. But you didn't have anyone like in your school or anything that you could have had an intimate relationship with?
No, I mean, I had a girlfriend in school, but I never had like sex with her or something like that.
Right. So did you try to have sex with her before?
Yeah, but she just
You said
she
no,
did, she just did.
she
No,
wasn't ready.
yeah,
All right. So do you understand now, Mr. Cox, that you that like a minor cannot consent to having sexual intercourse?
Yeah,
And so, have you learned how to manage your preoccupation of sexual activity? You said that from watching pornography, it was almost like your desire to have sex was heightened. Is that right?
yeah,
Have you learned how to manage that without reoffending?
yeah, a lot. Like, I mean, being here, it just, I look back at like my life and it was just not right. It was just, I know what I did, it was shameful and like, it was just bad. And
It was, but how has your sister been handling this? Has she recovered?
yeah, she went to therapy for a while, but now she's fine and she's doing good.
And how old is she now?
14.
Okay. And I saw that your parents still come to visit you. Is that right?
Yeah,
So I'm glad to see that you were able to complete the treatment. Tell me what you learned from that treatment, the problem sexual behavior treatment.
I learned that there's a lot of people that have problems, right? Attracted to minors, and I learned how to like deal with certain stuff, like when you feel it in a moment, or how to prevent it from happening. And
But you're not attracted to minors, right?
I mean, not like all the stuff they talked about it. I don't really feel like identified with that.
Okay, right. That's what I'm saying. So it's not a specific type of person. It's just you just wanted to have sex. And you keep saying that you've learned how to manage that, but what do you do to manage that? Do you work out? Do you listen to music? Do you go for a walk? Like what kinds of things? How do you handle that?
But handle what? Like,
Your desire to have sex with just anyone.
I mean, you can't really. I mean, I've been times of like, yeah, I've been trying to work out and just do stuff that like I'm just trying to learn stuff every day.
Yeah.
I've been reading.
Reading, okay.
Yeah,
So you're pursuing education or personal you're trying to personal motivation, like from reading and stuff like that.
yeah.
I just have a few more questions for you. Do you think that this happened because your sister was there and you had opportunity to do it?
Yeah,
But going forward, did you understand that, again, that's not something that you can do here, right?
yeah.
You have a number of disciplinary infractions. It looks like you received court for refusing housing. Why'd you have a blade?
It wasn't a blade. It was just a piece of metal. Like I used to fix stuff, so I was using that like to fix headphones and stuff like that.
Okay, okay. So why would you drink Pruno in prison? That's disgusting.
I mean, you know, everybody at some point they like you get sad or stressed, and sometimes you don't care if it's bad for you or not, and that's why I drink.
What were you stressed and you didn't care? What were you stressed about?
Huh?
What were you stressed about that you didn't care?
Just about everything, and just being in jail, and just sometimes breaks you down.
I can understand how prison would be a stressful environment, especially with your kind of crimes. So I just want to state that this is your only criminal offense. I want to congratulate you on obtaining your GED. That is a tremendous accomplishment. Hopefully you will be able to take that and pursue, other financial endeavors like a job or pursue your education even more. But I understand that test is not easy, so I commend you on that. I know that you took Unlock Your Thinking and the Tier 2 program to address your substance abuse, which I see that you were smoking marijuana and drinking alcohol. Tell us about your relapse prevention, your release plan.
Just plan to get my life right, get a job and just work and get money to get my house and everything, get my life right.
Okay. And I see that you have a protective order with the victim until 2030. How are you going to handle that? Where are you going to live?
I plan to live in Norwich. That's kind
In Norwich with who?
just, I don't know, but I just plan to live in Norwich. I mean, I like it there.
Right. I'm all set with my questions. Thank you for speaking with me, sir.
Thank you, Ms. Berry. Ms. Chance?
That's it?
Nope.
Oh, I have a question that I wanted to ask. So from what I read, the underage related person that you had sex with, that was not the first time that you had sex. Is that correct?
Nah, that was the first time.
I thought I read that your first experience was age 16.
Nah, I think that was early and I lied about it.
You lied about it?
Yeah, I think that was when I think somebody came to see me here, and I was just kind of
Why would you lie about something that significant and important?
I just thought it was embarrassing saying that I was still a virgin at 18-year-old.
Okay. But you understand that once you go back in the community, you have to attend treatment program. And whatever your participation is, you cannot lie, that you have to be honest.
Yeah, I learned that, and I'm willing to do all that. I'm willing to do all those programs.
I know you said you did not identify with the treatment program that you participated in. Was
Yes.
there a specific part of it that you could not relate to?
Yeah, they showed us a video, and there's really people that just really have a problem with attracted to minors. and they just don't feel comfortable being with like a person with the same age or older than them. So they really have a problem, and I don't think I had that.
That was not the problem, the issue for you.
No.
So you indicated that. So if you are released and you go to Norwich, you know, it would have to be a halfway house.
Yeah, I mean, it doesn't matter. Like I just really want to get out of here. It's just stressful here.
Okay. And you still have your parents who come to visit you as support.
Yeah,
So you know you cannot have any contact with minors.
yeah.
All right, well, you know, I wish you the best of luck, Mr. Shingo Cox. Hopefully I pronounced your name correctly.
Yeah.
And hopefully, if and when you go in the community, that you're just gonna follow whatever instructions you are given about, you know, attending the treatment program and following the rules that the probation or parole officer tells you.
Yeah.
Okay? All right. Good luck.
Thank you. I do not have any follow-up questions. Mr. Chin Cooks, we will now deliberate and give you our decision in just a few minutes. Ms. Berry?
Thank you, Madam Chair. So I have to say that the nature of this offense is very concerning. And I also have to say that the disciplinary infractions that he's received since he's been in the facility were also concerning. To his credit, he did complete the problem sexual behavior treatment. He also completed a substance abuse program. This is his only criminal conviction. He does have community support, and according to our records, he will require a halfway house before he'll be able to have any kind of direct contact with his family. So I am going to vote in favor of his early release because I believe that he needs the treatment in the community. And he is done with us in March of next year. He's not eligible for parole until July, so that is what, 6 months under parole supervision if we vote into parole.
Yes.
I am glad to hear that Mr. Chingo Cox is able to talk about what he did. He keeps calling her an underage person, and that's not what it was, but that's neither here nor there. I just hope that he gets the help that he needs and he avoids doing something like this again in the future. But my vote would be to grant discretionary parole with no contact with the victim, minors, the treatment that he needs out in the community, halfway house, and okay. Ms. Sheets?
I absolutely agree with everything that Ms. Berry said. I do think Mr. Kingo Cooks could really benefit from the community program and be supervised by parole before he goes on his 20 years of probation.
Yes, and he has lifetime registry as well. Okay. I had no alcohol. Did you say no alcohol, Ms.
I
Barry?
didn't say that.
Like no alcohol, halfway house. What do we think about a mental health evaluation and treatment? I think the mental health evaluation in the file talked about community services.
Right. I agree.
ICE detainer, problem sexual behavior treatment. I had a pornography restriction as well, and no contact with minors, and no contact with the victim without the parole officer's permission.
Well, there's a protective order, so whether or not he has a order, so you can't.
All right. All right, in the matter of Manuel Chingo Cox, inmate number 440051, I make a motion to grant discretionary parole on or after July 29th, 2026, with the following conditions: no alcohol use, halfway house placement, mental health evaluation and treatment, release to ICE detainer, community-based treatment for problem sexual behavior treatment, no contact with minors without the parole officer's permission, restriction on pornography, and no contact with the victim, ECC. Do I have a second?
Second.
All in favor? Aye. All right, Mr. Chingo Cox, we wish you the best of luck. There's a lot of conditions. Parole will explain them all to you.
And thank you very much and appreciate it. And
Do well in the community and you know, take advantage of the treatment.
yeah,
Okay.
This concludes the hearing for Manuel Chingo Cox, inmate number 440051. You're all set, Mr. Cox.
thank you, appreciate it.
Who else is screaming into their screens right now? I know when I first saw this, I was screaming. I think I saw it when I was listening to it when I was driving my car, and I'm just screaming. I'm screaming into my car. And thank God that I have this platform with you to share with you, because otherwise we couldn't listen to this stuff if we just thought that we were crazy, if we were all screaming the same thing. I know we were all screaming the same thing. The parole board came into this hearing with, I don't even want to call it an assumption, with the conclusion. The conclusion is that Mr. Chingo Cox, you can't make it up, isn't a chomo. The conclusion is that he's not attracted to children. No, instead the conclusion is that he just wanted to know what it was like to have intercourse. That was it. Of course, obviously. You know, it's like they asked, it wasn't even questions that they were asking. It wasn't even leading questions that they were asking. It was, you don't like children, right? You're not attracted to children. You just wanted to know what it was like, right? Yeah. There was no let him talk. Let him bloody talk. Not that there's any doubt in my mind. This is, this, we see chomos, right? This one is different. This one is very different. How many chomos have we seen come up to parole that have a write-up for drinking Pruno? It's almost unheard of. Maybe, a couple out of every, is it 1%? Is it even 1%? And he has a shank. He is not just a chomo. If I had to make Dr. Grande, I'm not diagnosing anyone. I'm only speculating on a situation like this. I know we don't have PhDs. I know clearly we cannot possibly come up with this conclusion. But if I had to guess, this man is one of those like serial killer level psychopaths. He is not like he's not even like a normal chomo. He is like the type of chomos that will collect bodies and dismember them and keep them locked up in their bed. All those things. He is such a different level. And I say this because you do not see chomos do this to, you know how old she was? 8. I did the math. he committed the crime on January 1st, 2021. He had this parole hearing on April 13th, 2026. The amount of time that he served, she would have been 8 years old. I put this in the chat GPT. You don't need to trust my math. He's 18. He is 8. And the conclusion for this hearing is that he just wanted to know what it was like. He was curious because, he watched a lot of adult movies and yeah, he had a girlfriend, but they put the words in her mouth. Oh, she wasn't married. Oh, she wasn't interested. Oh, like they put that words in. What? Well, the record shows that you said you started when you were 16. Ah, he smiles. He smiles. He's caught in a lie. He smiles. I just didn't want anyone to know I lost my virginity on my sister. Like he lost it. He SA'd her. You can't. And then they have the that. Did your parents forgive you? Yeah. What about your sister? Yeah. Like the idea that a parole board can even say that. Do you realize how sick that is? She didn't forgive him. The only thing that could have happened is that she was manipulated as the child that she is, being 14 years old today, into forgiving him. You never forgive someone for that. He has now, you gotta say, you can't even blame him for having a bad parole hearing. The parole board came in here with an idea in their head, for some reason coming to the conclusion that the person sitting across from them is not wired differently. No curiosity to the fact that, oh my gosh, we have done parole hearings for thousands of chomos, but none of them ever have tickets. But not only does this guy have, he has 2 tickets. He is a shank and he has substance abuse. Not only that, but what's crazy, they say, well, this is his first felony on his record. Well, being that it's Connecticut and he was 18, like he wouldn't have had time to have it. It would have been his juvie record, which he wouldn't even brought. Like where they come up with these hoops that they jump through. But not only that, the strangest thing is that he was like a moderate risk to reoffend on the regular offense registry. So I guess his write-ups affect his score. Even their own algorithm says it is something messed up. And he was a moderate risk on the static 9-9, which is unheard of. Unheard of completely. So even, what was it? Who said it? Was it Miss Barry? Like, I hope that you don't reoffend again. She says, I hope you don't reoffend again. What else am I missing? Right. When he talks about the Pruno, they actually say, I understand how prison would be stressful with those kind of crimes. I understand why you would drink Pruno. Who says that? Had this been like a Judge Bonnie Jackson hearing, a No Way Roche hearing, Miss Stapleton hearing, mostly I'll say, like, I want Judge Bonnie Jackson from Louisiana to have taken this case. She would have probed. She would have asked questions. She would have gotten out of him everything. We would have known exactly what was going on in his mind. And instead, we are left with whatever the parole board wanted it to be, which was that he's not a chomo, he's not wired differently, he's not a psychopath, sociopath, he's not like potential serial killer material, in my opinion. Instead, he just wanted to know what it was like. Like, your brain blows up. It just it explodes. You can't digest this type of information. And this poor girl, The no contact order is only for another 4 years until she's 18 years old, and then he's gonna be back in that house. He's gonna have access to her friends. I mean, maybe she'll be safe by then. He's only into 8-year-olds. You know, the crazy thing is he is going now. He has an ICE detainer, and I spoke to Sir Richard about this. Now, you notice they were talking about it as if like there is no ICE detainer, and that's because it's my understanding Connecticut doesn't exactly want to play, doesn't like to play ball. I don't know with the feds. I don't really know, but they didn't. You know, otherwise they would have just said, "Oh well, he's going back wherever." Like, why even? Who cares about restraining orders and all this stuff? So it seems like they're under the assumption that the detainer is not gonna nothing's gonna happen. That just seems that was my takeaway. I can't look it up because he's not getting out until July. I'm recording this in May. So yeah, I mean, well, I guess we can revisit it in July and see if he gets deported, but it doesn't seem like that's going to be the case. So, anyways, the of course I know that there are a bunch that I'm missing here, a bunch that you probably thought of that I forgot. So leave it in the comment section. But we're gonna go and see another hearing, and this hearing is a revocation saga. It's also totally insane. It's for a monster who listen to this. I'll have to break it down to you because it's so crazy. Um, it's it's for a monster. Let me pull up my screen. Who in 3/21/2017 was found with illegal possession of CP, right? He was given, let me pull up the article for you, but he was given 4 years special parole 6, released on 12/3/2020. But this wasn't, he actually was given probation. So he violated his probation, went to prison, and then since then he continues. In 2023, he got failure to register, and then he gets violated again several times, which we're about to watch. But the content that he was looking at is so disturbing. And let me pull it up. Manchester man arrested on CP, right? This was 2017. Man who was on probation. So he was already on probation. So I actually got it wrong. He was already on probation before this 2017 charge. So what I showed you, the 2022, is these are newer charges, right? So this is an habitual offender. This one goes back to someone who was already on probation to 2017. They found the CP on his computer. One of the images pulled on Kobe Ellison's laptop depicted an Indiana girl who was a victim along with her twin sister in a 2024 CP case. And apparently this is an infamous case that is spread around America. Ellison, 21, Manchester, was charged with possession of CP. He was being held on $500,000 and is scheduled to appear in Manchester. In April 2016, he was sentenced as a youthful offender to 4 years of probation. The warrant says the crime for which he was convicted was not specific, but a probation officer with the offender supervision unit was assigned to his case 4 months after sentencing, just 4 months. So he's sentenced to probation 4 months after the probation officer takes his computer and other digital devices, handed them over to the police when Ellison admitted he had viewed online adult content, or just online content, I guess. We have to assume it wasn't adult. On the seized laptops, investigators found images of girls 6 to 11 and videos depicting 9 and 14. But I'm sure the parole board would just say, he's just curious, right? In various states of undress, the warrant says. The video was identified as chat sessions. And by the way, this is like all foreshadowing to the revocation cases we're about to see. The National Center for Missing and Exploited Children and Indiana State Police identified a girl in the photograph as a victim along with her identical twin sister in a case that state. Their twins' father had done this. In 2004, according to the warrant, the man was convicted in 2010 and sentenced to 38 years in prison. We know that 38 years is all gaslighting. I don't know, maybe it's that this state it's different, but the production of the image of propagation throughout the internet, we have immeasurable effects on the victim. So basically, these images that this biological sperm donor created years ago of his twin daughters, and this is where you see the direct effect, right? You have these monsters. So he he commits a crime in 2016. He gets probation. He violates in 2017. He gets out. He commits more crimes. He gets another one in 2022, and then we're going to see that when he gets out, he continues to he has no impulse control. They keep finding devices where he's chatting with people, and they're finding search words. Now, I'm going to preface this. Please listen to me when I say this, because I say these things and then I see in the comment section. I edited out. I used a software to do it. Where they talk about all of his websites that he uses in the revocation hearing and the search terms that he uses in the website. So you might not really notice, it just jumps through. But the parole officer is listing out and reading the search terms and the websites. None of the websites that he goes to are illegal websites. They seem to be mainstream websites. The search terms that he uses, though, are so vile, right? He's like, had he gotten caught doing these searches, he wouldn't go to prison as a normal person. But it's clearly indicating that he's trying to gain access to to his fantasies, like he's going to anime sites and things that are and search terms about little people, like it's horrible things, right? But he's doing it so he can't get a new felony. And he's getting caught and he's getting revoked because of it. And it's just, anyways, I bleep out all the words because otherwise the YouTube channel would just get totally smashed. And what am I supposed to do? But that's why, that's why you won't hear what he's actually searching for. But it is the most vile searches. It's disgusting. Anyways, so with that, let's jump in.
Okay, so you'll now review the charge, the state your foster is bringing against you, and the information underlying each charge. So P.O. Hudavenko, please read the charges.
Right. Charge 1 under mental health treatment on 11/1/2023, 11/7/2023, and 11/22/2023. You failed to attend individual mental health appointments with your CRT clinician as scheduled. Your actions violate your mental health treatment condition as well as your parole officer's direction. You are placed on home confinement with the exception of treatment and signed a misconduct for your behavior. Charge 2, restriction on 4/28/2025. You were found in possession of an undisclosed cell phone that did not have monitoring software installed. A search of this device yielded multiple searches including searches for this device also possessed multiple images of. You signed a written statement attesting that you had been using this unmonitored device for at least 1 year for viewing. Your actions violate your signed special parole agreement and your CTPSB treatment agreement. Charge 3, enhanced internet and device monitoring. On 2/16/2024, during a home visit at your residence, a total of 4 unauthorized and undisclosed electronic devices were discovered, including 2 Nintendo Switch consoles, a PlayStation 5 console, and a Steam Deck. All 4 items had the ability to access the internet, and none had been approved by your parole officer or had device monitoring software installed. You were referred to CBT treatment and signed a misconduct for your behavior. On 4/28/2025, you were found in possession of an undisclosed cell phone that did not have monitoring software installed. The search of this device yielded multiple searches for, including searches for, and this device also possessed multiple images of, as well as undisclosed social media use, including Twitch, Twitter/X, and Discord. You signed a written statement attesting that you've been using this unmonitored device for at least 1 year. Your actions violate your signed special parole agreement and your CTPSB treatment agreement. Charge number 4, problem sexual behavior treatment. On 2/16/2024, during a home visit at your residence, a total of 4 unauthorized and undisclosed electronic devices were discovered, including 2 Nintendo Switch consoles, a PlayStation 5 console, and a Steam Deck. All 4 items had the ability to access the internet, and none had been approved by your parole officer or had device monitoring software installed. You were referred to CBT treatment and signed a misconduct for your behavior. On 4/28/2025, you were found in possession of an undisclosed cell phone that did not have monitoring software installed. A search of this device yielded multiple searches for, including searches for, and this device also possessed multiple images of, as well as undisclosed social media use, including Twitch, Twitter/X, and Discord. You signed a written statement attesting that you've been using this unmonitored device for at least 1 year.
Did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yes, I did.
Okay. Do you need to continue this hearing to obtain any additional evidence?
No.
Okay, we have no witnesses today. At this time, the state will have an opportunity to make a short statement or testify with respect to probable cause, the severity of the allegations. I am going to swear in you, Mr. Pio Hodovenko, as well as Ms. Ellison. I'm going to swear you both in the event that you would like to speak today. So can you please both raise your right hand? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give in this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Yep.
All right. So at this time, it's the state's opportunity to speak if you would like to.
Sure. So just in respect to probable cause and then the severity of the violation, this phone by Ellison's own admission with the signed statement was being used for at least a year, unmonitored, unsupervised, unapproved, to violate multiple conditions of his special parole release. His instant offense of possession is the basis for the enhanced monitoring condition that the board imposed on his release, and he was violating that for at least a year that he admitted to. And these actions of using unmonitored and undisclosed electronic devices were the pretense for the violation of probation charge that led to the instant offense of possession. So these behaviors have repeated for a number of years, and community supervision and problem sexual behavior treatment have clearly not helped the offender to stop these behaviors. That's all I have.
Thank you. Is now defense's opportunity to respond, making short statements, testify with respect to probable cause and severity of the allegations.
Thank you. In regards to charge 1, mental health treatment, we would submit there's insufficient evidence for finding a probable cause. The allegation alleges that my client missed 3 appointments. However, my client was still actively engaged in that treatment, continuing to go and was in that treatment up until the time of remand. I would suggest to you that simply missing appointments is not a violation of the condition of mental health treatment itself. Again, my client was continuing to attend that treatment. These allegations of missed classes go back to November of 2023. And again, my client was still working with CRT at the time of remand. So continue to be in that programming without a discharge, an unsuccessful discharge. In regards to, no comment as to charge 2. In regards to charge 3, addressing the first portion of that charge, which begins in paragraph on 2/16/2024, we would suggest there's insufficient evidence for finding a probable cause in regards to just that first paragraph, in so much as there's no evidence submitted that the devices actually had internet access, that they are even in working order, and that they even belong to my client. My client was being sponsored by an aunt who at some point in time had a child that lived with her. And there's no evidence to suggest that my client was in possession, solely in possession of those items, that those items even had the ability to access the internet. We simply don't have any evidence submitted to support that. So in regards to just that portion of that charge, we would suggest that there's insufficient evidence for finding a probable cause. And again, that's a duplicative allegation as it appears in charge 4 under problem sexual behavior, the first paragraph there. So the same comments in regards to that portion. Nothing further as to the charges.
Thank you. Is there anything else from either side?
No.
I would just briefly add that Ellison signed the misconduct for that home visit on the 16th. PlayStation 5, Steam Deck, Nintendo Switch are all consoles that have internet capability. they were devices that Ellison was clearly aware that he was not to be possessing, as evidenced by his signature on the misconduct and those items being confiscated. So that's all I have in regards to the paragraph I notes.
All right, thank you. So I'll be right with you. My decision. All right, so I'm gonna announce my findings. On regarding charge 1, I do make a finding of probable cause, mental health treatment based on evidence presented, exhibits A, H, and G. On charge 2, I make a finding of probable cause, restriction on based on the evidence that was presented in support of the violation, which is exhibits A and I. Regarding charge 3, I make a finding of probable cause on, I am going to separate this into part 1, part 2. On the date of 4/28/25, I do make a finding for enhanced internet and device monitoring. This is based on exhibits A, G, and I. Regarding part 1, I make a no finding. This agreement was signed on the same day of 2/16, but it was signed on the same day of 2/16/24. So I believe there's insufficient evidence regarding part 1, is that charge was just added on that same day. On charge 4, I make a finding of probable cause on problem sexual behavior treatment. Regarding the part 2, regarding part 2, the date of 4/28/25, based on exhibits A, E, F, and I make a no finding on the first part, due to the same reason as previously stated, regarding the other charge that I had just read, the date of 2/16/24, and the CTPSB treatment agreement was not signed until March 27th of 24 regarding that condition as well. So I do find the act of serious enough to warrant revocation. I've determined you should be detained while you wait for your rev hearing. So I am going to schedule you for a revocation hearing. So I'll bring you back. These are technical violations. So we have 60 business days to return to custody to schedule that. So I will see you soon, and you will be notified when that's rescheduled for. Pio Horbanco, do you plan on being at the rev hearing as well?
I would like to, if possible, please. Thank you.
Do you have any questions?
No, I do not.
Okay, so we'll bring you back and we will see you very soon.
Okay.
Okay, thank you,
Thank you very
Attorney
much.
Jones.
Thank you.
Have a good day.
You too.
Have a good day.
Have a good one.
Thank you very much.
So that was the preliminary hearing. So now they're going to come back. So basically, in the next hearing that we're about to watch, they can't bring up like part 1 and like part 2 of part 2, not because he didn't do it, but because he didn't sign the contract until that date. So it's like you see the PO officer when as soon as the person gets out, it's to run over, you get them to sign the contract, and until then they can do whatever they want. It's pretty crazy, right? The cars are always stacked in the offender's favor. They also get an attorney whose job it is to defend their client, and they're defending them against a PO officer who's run around with a gun, a bulletproof vest, herding kittens and chomos, and has to go up against an attorney. And then there's an interviewer that says, well, I know that you did do these things, but since you didn't sign the contract until like that morning, then no, you can't include it, which in my opinion is really just, again, it's an adversarial process that is stacked in the favor of the inmate. And he's living in a home where there is a child or there was a child. That's crazy. And yeah, all those devices, of course, it's not theirs. And of course, there's no proof that it has internet connectivity. Shut up. You know why he has. And here's the thing I want to point out. It's my understanding they never tested those devices yet. It's more like they had them. And okay, so there was a part, well, I guess they searched the devices. So there's a part that you missed again, and I'm sorry for this, but they read off in the findings that on the devices, he's searching tons of things, right? So he's going to websites. I've never heard of most of the websites. They're not common names, but I assume they're legal. And he's searching things like, R words, girl getting R word, or he's searching things about stepfathers and their children, and or little girls getting, so he's searching those keywords. It was full of them. It was like a minute long where the PO officer had to read off the list. So without hearing them go through it, it's not as much. It's like, oh, what's the big deal? He has like some unmarked devices, but he's going there and he's searching for the most disgusting, vile things that trigger his fantasies, what his initials crying for. You just don't get that. I had to remove what I don't know what to do. Either I bleep it out or I don't know. I don't really like, maybe I should have bleeped out each thing, but it takes like 20 minutes to bleep out a few words, and then it gets demonetized, and then it gets suppressed, and then I don't know. I'm trying this out. Let me know what your thoughts are.
You solemnly swear, solemnly affirm, as the case in B, the evidence shall give for this case to be the truth, the whole truth, and nothing but the truth, so help you God, upon penalty of perjury?
I swear. I do.
Okay, so it's the state opportunity right now, if you'd like to say anything in regards to charges?
Sure, just briefly, the Board of Parole imposed, specifically the restriction on condition, as well as the enhanced monitoring stipulation to manage, the offender's behaviors, attempt to reduce his risk. But clearly those have proven ineffective. Ellison's criminal history is solely comprised of, despite years now of incarceration as well as community supervision, the offender, remains either unwilling or unable to abide by those conditions. So, I just wanted to ensure that, that risk posed to society and to children are just, kept front of mind when recommending a sanction based on these behaviors.
Thank you. So it's not a defense opportunity, but speak to any of the evidence.
Yeah, thank you. I just for clarification purposes, in regards to charge one, there's a no finding, and then in regards to charge,
The all dates of 2/16/24, there's no finding that.
okay. Okay. All right, so in regards to the charges, what remains, I have no comments.
Okay. So what I'm gonna do next, I'm gonna announce my findings. So as I had just stated, charge one, mental health treatment is not taken consideration, no finding was made at the time of the preliminary hearing. Regarding charge two, I do find you violate condition restriction on based on evidence provided in support of the charge, which is exhibits A, J, and I. On charge three, I do find you violate condition enhanced internet device monitoring based on evidence that was provided, which is exhibits A and I, and that is for that date, as I stated, at 4/28/25. On charge four, I do find that you violate condition problem sexual behavior treatment based on evidence provided for the charge. This is for the 4/28/25 date. This is based on exhibits A, E, F, I, and J. That includes the fact finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, council will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. P.O. Hodabanko, would you like to say anything at this time?
Really just to reiterate what I said before, just that, Ellison, unfortunately, supervision and then these enhanced monitoring conditions of software placed on electronics have clearly been ineffective and unable to kind of stop these behaviors. And the behaviors are intentionally obscuring and avoiding detection of treatment and of myself. These behaviors mirror the situation that led to a violation of probation previously, when Ellison was supervised by Manchester probation. So yeah, again, I would just recommend that whatever sanction the board deems appropriate is just commensurate with the risk posed to society, both internet and in the public.
Thank you. I'm gonna turn it over to council.
Thank you. My client is 29 years of age, single, no children, does have support in the community by way of his aunt as well as brother. Fortunately, his mother passed away at the end of November of 2024. So his main support system is his aunt. did receive his GED while in the Department of Corrections. Colby does live with mental health issues, and I believe is attempting to address that during the time period, both in the community as well as in the Department of Corrections. During this time period of supervision in the community, I believe Colby was being successfully supervised for a period of approximately 1 year and 8 months, and during that time period, had successfully completed the Open Hearth Halfway House, the Connection Reentry Assisted Community Housing Reach Program, where Colby was at the time of remand. In addition to that, Colby was attending CRT in Hartford for individual psychotherapy, attending adult probation in Hartford for problem sexual behavior, and was reportedly successfully discharged from that group, or at least successfully completed the treatment portion, however, was not officially successfully discharged due to the remand. Was able to gain employment working at Teriyaki Madness in Manchester doing customer service, as well as working at Shake Shack in West Hartford for approximately 8 months. During the time period that Colby has been with the Department of Corrections on this remand, which I believe has been approximately 2.5 months, Colby has been seeing mental health bi-weekly for individual counseling, is in the process of being evaluated for medication, mental health medication, and has spent some time reading and reflecting on how better to be successful in the community. In addition to that, also Colby's on the wait list to be a Tierman, trying to get a job in the library as well, and has been speaking with his aunt frequently. And again, his aunt is willing to sponsor Colby upon any supervision, re-release of supervision to the community. His aunt is listed as his sponsor, Melody Ellison. Her information is contained within Defense Exhibit 1. Colby's open to all employment opportunities as well as all treatment opportunities. Looking at the violation and what is left in terms of where findings were made, I simply would point out, and not to minimize the conduct, because again, it is a violation of conditions that are placed on Colby. But there's no allegation that Colby is accessing child. There's no allegation that Colby is attempting to meet with children in the community or violate, which I would say would be a risk to public safety. You do have a violation here, and again, there was a finding made, but the violation consists of restriction on, which in this case is adult. Colby is on supervision until, I believe, the end of sentence is December of 2026, early December 2nd of 2026. And after that time period, there will be no supervision to follow. So taking into consideration the nature of the violation and the conduct, and again, it's adult that is alleged to have been accessed here. We would obviously be asking that Colby be re-paroled into the community so that there is supervision in place. There is some way to transition back into the community prior to the end of sentence on special. Thank you.
Thanks. Is there anything else from the state before I make a recommendation?
No, I have nothing further. Thank you.
All right, so I'll be right with you with my recommendation. So I have reviewed all the evidence. I have listened to testimony provided today. Just to put on the record, offender was in the community for approximately 1 year and 8.5 months before he was returned to custody on this violation. There's a prior criminal violation which does contain the same types of behavior that is displayed in this violation. Did receive a 3-month sanction for the last violation. His recommendation of 1 year incarceration. He is on special parole till December of 2026 for special parole. 2 misconducts were received during this 1 year and 8.5 month period that is noted. Based on this information, also taking into consideration no findings that were made, I am going to recommend that parole be revoked and they be re-paroled for January 22nd of 2026, which is an approximate 9-month period confinement as a sanction. I recommend the following parole conditions: enhanced internet and device monitoring, problems such as behavior treatment, mental health treatment, medication compliance, no contact with minors, and restriction on my findings going to the parole board on July 17th The board can agree with me, they can let you out sooner, or they can also hold you in and max out your special parole if they like to. So if they want you in longer, they bring you back to talk to you and about why they may want to hold you in longer. If they agree with me, you'd be released January 22nd of 2026. We'll get it in writing about a week after, July 17th, from the board, what their decision is and what your conditions would be if they're going to re-parole you or not. You can also speak to the attorney regarding what the board's decision is on that day. Do you have any questions?
I do not know.
No?
No, I do
Okay.
not.
Yeah, so I mean, you need to obey your parole officers, or else you're gonna spend the rest of your time inside, which I'm sure is not favorable to you doing better in the community. So trying to give you another shot to be in compliance with parole. And hopefully you'll get it right this time and participate in treatment and complete that before you're done. So if you're all set and you have no questions, then you're good for today.
Okay, thank you.
And Colby, if you have any questions, you can contact me, and I would say contact me after July 17th, so at least that way we know with the board, if the board accepted the recommendation, okay?
Okay,
All right, good luck.
Good luck.
thank you.
Thank you, Fiona Benko.
Thank you both. Have a good day.
Have a good day.
A 9-month sanction for this innocent Bebe Angel Aladdin. I mean, I know that he clearly was only playing games with his Nintendo Switches, and I know that there was no way he was doing anything really that nefarious with all of those hidden devices. So I think that 9 months is fair. Surely he's a low risk on the static 99. Surely he will never commit such a crime like this again. As a matter of fact, I think if there's one thing for certain, it's that we will never see Mr. Ellison again.
Good morning, Mr. Ellison. I'm just gonna contact your department officer and then we'll get started, okay?
Okay,
18 days. 18 days is how long he lasted. And by the way, it probably would have been shorter because it took just 4 days from the time that they installed the tracking software on his phone for them to pick up more illicit searches. So I don't know how long he would have gone with the device or why they waited so long to put the tracking stuff on, but he has no self-control, no impulse control whatsoever. He knows the tracking devices are on the phones and he went and did the searches anyways. And lest I remind you, I think this is important. I used, again, I'll say it again. I use the editing software to remove all of the words. So every time the PO officer talks about something, you're not hearing it. And I know this is a horrible experience, but there was no way else to show this without either a bleep every 3 seconds or the channel getting nuked. And I ran it through a software that said remove any word like this. He was searching the most horrific things. He was searching the most, with the content that he was searching was with the R word in it, little kids getting R word, and the in the worst ways. That's the kind of stuff that he was searching. He is a monster. And then do you get that? Did you hear that he's living with his aunt? And then his attorney said that the Nintendo Switches could have been the aunt's child's device. So they let him live with a child? Are you out of your mind? And this is the point that we need to make time and time again. I'll never tire of it. It's absolute madness. Now we're going to go and watch his next revocation hearing. It's pretty much the same exact offenses. Shocker, shocker. And we'll go from there.
Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I swear.
I do. Thank you. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
I do not.
You do have important rights for today, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, I did.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights? Now you're ready to go forward.
Yes, I do, and I am.
Thank you. We are now going to read the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So, Officer Devada, can you please review the charges for us, starting with number 1, restriction on?
Yes, restriction on 2/3/2026, IPPC, enhanced internet and monitoring software was installed on your phone. On 2/9/2026, your supervising officer conducted a review of this software and you were found to have access and viewed on 2/7/2026. Further condition, restriction on at no time are used to access or view this material. Problem sexual behavior treatment. On 1/28/2026, you completed your intake with the Center for the Treatment of Problem Sexual Behavior and signed your treatment agreement. Per your treatment agreement, you are not to engage in social media chats. A review of your enhanced internet and device monitoring revealed that you downloaded the Patreon and Crunchyroll app, set up a profile, and entered chat. The same review of IPPC monitoring conducted on 2/9/2026 yielded results of you viewing on your cell phone. At no time were you given permission by CTPSB staff or your supervising officer to view, which violates your treatment agreement. You were unsuccessfully discharged from treatment.
And you've also submitted evidence in support of the case. Can you please identify the evidence for us, the exhibits?
Yes. A, remand to custody order. B, conditions of parole. C, parole violation notice. D, parole violation report. E, CTPSB treatment agreement and discharge letter. F, IPPC enhanced internet and device monitoring evidence. G, photos taken of Allison's phone. H, BOP revocation hearing summary 7/8/2025, and that should be I, miscellaneous.
Thank you. And then I'm also going to identify, I did receive a halfway house agreement. I'm just going to separate that as Exhibit J. So counsel to confirm, did you and your client receive the notice of parole violation? Parole violation for and all the other documents identified for today?
We have.
Thank you. And I have not received anything from the defense at this time. Counsel, do you need time to submit any documents?
Not at this time, thank you.
And we do not have any witnesses. So at this time, the state will have an opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So Officer Devada, are there any comments at this time or statements?
Yes, I would just like to say that Allison had just served a technical violation for very similar behaviors, and it was just very alarming that within only 3 days of receiving his cell phone, he was already engaging in risky behaviors that ultimately led to remand and discharge from CTPSB treatment. So I do think that these charges are severe enough to warrant a further revocation hearing. Thank you.
You and counsel?
Yes, thank you very much. I do just want to put a few things on the record regarding my client. First, I would note my client has been suffering. He did unfortunately lose his mother, I believe about 15 months ago. And since that time, he has been grieving and going through a number of internal struggles related to that loss. He acknowledges that he could definitely benefit from therapy in the community. And I know he's very anxious to get all of that straightened out and set up prior to his parole expiring later this year. As to the charges themselves, I do just want to note a couple of things concerning the alleged stuff that was being viewed. I would just note that none of these items were illegal images or videos. If my client was not on parole, I would argue that this wouldn't necessarily be an issue. Secondly, I would note concerning the downloading of the apps, the Crunchyroll and Patreon, I would just note these two apps that they're alleging he patronized are not in and of themselves social media sites. I think that Crunchyroll can kind of be explained similar to like a Netflix, but specifically for like Japanese anime type movies. And then Patreon is often used for podcast and content creators. And it's similar in a way to Spotify, where it shows what the creator posts every day. So I would just note that those, the primary function of those two sites is not social media. And I would also note that given the evidence that was submitted at, I believe it's Exhibit It's unclear with the chat what site that's allegedly on, or if my client himself actually was involved in the chat. I see some of these messages, but it's unclear who these are being sent to or from. And then lastly, I would just note, I think, it is somewhat relevant to bring up in my review for this case, and looking at the parole revocation statutes, regulations, and memoranda, the term are not defined. I understand that, that's certainly not something this hearing examiner has control over, but I thought it was relevant to bring up because I think that can lead to some issues if the client is not effectively put on notice of what we're discussing when we say yours. But those are my comments. Thank you very much.
Thank you. Any additional comments from the state?
Yeah, I'd just like to mention that if you look further into those apps that were downloaded, the Patreon and the Crunchyroll app, they're actually anime that's known for content to include. So I just don't really think that that's appropriate based on Ellison's history to be downloading apps such as that. And he did create a profile and entered those chats. Whether or not he commented really doesn't matter. He is not supposed to access any type of media, whether it be Reddit, anything that would have the component to chat with other people. Thank you.
Yes, just very briefly, I would again just, reiterate, we're not, discussing actually, the searches or anything here. I'm just trying to note that, as far as this app itself, Crunchyroll, it's not, like a situation where there's, it's not like a website in and of itself. It's not a situation where the only thing on that website is, it's just like, I think on Netflix, you could probably find a movie that has in it. I think that that's somewhat akin to what we're looking at here. Thank you.
Thank you. Officer DeBell, I just want to confirm one more time. Do you have any last comments?
I'm sorry?
Any additional comments?
Yeah, I mean, so where he was actually viewing that were not either of those apps. Those apps are for the anime sharing. So I just want to make sure we know the difference. So he was actually accessing from other avenues and admitted to doing so. Thank you.
Nothing further. Thank you.
So I am going to announce my findings. On charge number 1, Mr. Ellison, I am making a finding of probable cause for the condition of restriction based on the evidence presented in states exhibits B, D, F, and G. And on charge number 2, I'm also making a finding of probable cause based for the condition of positive sexual behavior treatment based on the evidence presented in states exhibits B, D, F, and G. I'm also going to find that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you await the revocation hearing. So the records office at the facility will be notified of that. Your officer is aware of it now. So what happens next, Mr. Ellison, is that we will schedule you for a revocation hearing within 60 business days of your remand to custody. At that hearing, myself or another hearing examiner will determine if you violated the conditions of your parole, and if so, that hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So that does conclude today's hearing. Any questions?
No, Mr. Ellison, I'll set up a legal call with you so that we can discuss everything, and then my social worker will also be reaching out, okay?
Okay.
And that was the preliminary hearing, and good job on the PO officer really laying down the facts, knowing what she's talking about. Now we're going to go and watch his official hearing. This is now the hearing where they can take into account what passes as evidence or not, and then they say how long will get revoked for. And again, just take a step back to remember that it was 18 days that he got back into the community, but that doesn't count. It was 4 days from the time that they put the tracking devices on their phone. I don't know why does that mean, did he have a phone up until that time for 14 days without any type of supervision? So they put the tracking things on his phone. Can you imagine this full grown adult? We need to prove. Why do you even have it? Just take the phone away from him. But no, that would be against his rights, right? Well, whatever. So, and all this stuff, all this communication, he's talking probably he's the chats and the comments and this, and remember, they're not running the device through like a Celebrite device and doing like all these analytics. Otherwise, when they do that, because we've seen hearings where they run devices through the Celebrate machines, third-party machine that actually sees what's in there, that gets through encryption, right? They're not doing that. He's, I think, just going into the search history, because when they do Celebrate searches, the PO officer brings the receipts. They have to say they use Celebrate. They bring all the receipts and proof. We've covered revocation hearings like that. So we don't really even know what he's doing. We just know with the naked eye of the PO officer that they're seeing him going to websites and doing searches and engaging with people. That's what we know. Again, let that sink in. And I have no idea what Crunchyroll is, but apparently it's an anime thing, which anime has, I know there are people, and I never understood anime, I cannot wrap my mind around it. But then again, I love South Park, and I know there are people that don't love South Park. But I know that anime has a bad side to it, where it's apparently connected with, PDF files and whatnot. And that's probably, I think the PO officer was laying down the law, laying down the facts, saying, yeah, okay. Yeah, let's be nice. I love the attorneys. They have to do their job, but it's like, yeah, I'm sure there's nothing nefarious here. And okay, so anyways, let's go into the revocation hearing. But just think about, again, one thing to sink in is that he has no impulse control. None. He knows that he's going to do these searches, he's going to get in trouble, and he can't help it. Think about how dangerous this thing is. It's not if he will create new victims, it's when. The only if is if he will get caught, or when he will get caught, or how many victims he will create before he gets caught. Oh, but his mother died like 18 years ago. If they have to say that one more time, it's unreal. Anyways, let's jump in.
Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, to help you God upon penalty of perjury?
I swear.
I do. Thank you. So we're going to go over the procedure for today. So first, I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
I do not.
So we will go over your rights for today's hearing. So first, you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
I did.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I do, and I am.
So you're now going to review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. Officer DeValle, can you please review the charges for us, starting with number 1, restriction on.
Charge number 1, restriction on 2/3/2026, IPPC enhanced internet and monitoring software was installed on your phone. On 2/9/2026, your supervising officer conducted a review of this software where you were found to have access and viewed on 2/7/2026. Per your condition, restriction on at no time are you to access or view this material. Charge number 2, problem sexual behavior treatment. On 1/28/2026, you completed your intake with the Center for the Treatment of Problem Sexual Behavior and signed your treatment agreement. Per your treatment agreement, you are not to engage in social media chats. A review of your enhanced internet and device monitoring revealed that you had downloaded the Patreon and Crunchyroll app, set up a profile, and entered chats. The same review of IPPC monitoring conducted on 2/9/2026 yielded results of you viewing on your cell phone. At no time were you given permission by CTPSB staff or your supervising officer to view, which violates your treatment agreement. You were unsuccessfully discharged from treatment.
Thank you. And the evidence submitted by the state was already identified at the preliminary hearing, and that one does remain the same. Counsel, just to confirm, you and your client did receive the notice of parole violation, the parole violation part, and all the other documents identified for today?
Yes, we have. Thank you.
I did receive exhibits from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. And Exhibit 2, a support letter from Alexandra Fritz. Council, do you need time to submit any other documents?
We do not, thank you.
Don't have any witnesses. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. So Officer Zavada, any comments at this point towards the charges?
Yeah, I just want to reiterate that, Mr. Ellison had just served a 9-month sanction for a technical violation for the same exact behaviors. And within 3 days of getting the IPPC monitoring installed on his software, he knowingly looked at material he's not supposed to be looking at. So this is just very concerning. Thank you.
Council?
Yes, thank you. I would just renew my comments and arguments that were put onto the record at the preliminary hearing, and would just again note that based on my review of the parole regulations and statutes, I didn't see the term defined, which I do think deserves some consideration, but no additional comments. Thank you.
Thank you.
I would just like to comment on Ms. Dean's comment on when I confronted Colby about these actions on the IPPC monitoring, he did admit that he looked at these things knowing it was wrong. So that just kind of illustrates that he knew he wasn't supposed to be doing that. Thank you.
Yeah. Council, anything further?
Nothing further. Thank you.
Just take a quick moment, announce the findings. So on charge number 1, so I have listened to the testimony today as well as what was put on the record at the preliminary hearing. I reviewed all the evidence submitted. So with that, Mr. Ellison, on charge number 1, I am finding that you violated the condition of restriction based on the evidence presented in states exhibits B, D, F, and G. And on charge number 2, I'm also finding that you violated the conditions of problem sexual behavior treatment based on the evidence presented in exhibits B, D, E, F, and G. So that does conclude the backgrounding portion of this hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history. Once the state is finished, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I would recommend. So Officer Butler, any statements towards Mr. Ellison's background and history?
I just want to state that Mr. Ellison has had both inpatient and outpatient problem sexual behavior treatment. We've installed the device monitoring. We have, parole supervising him, and it just doesn't seem to be deterring these behaviors. So we are requesting a full revocation at this time.
Thank you. And counsel?
Yes, thank you. My client, Mr. Ellison's 30 years old. He was born in Germany, but raised in Connecticut. His greatest support in the community are his aunts. He did unfortunately lose his mother in 2024, which has been very difficult. Most recently, he utilized Cheney House while he was on supervision. Previously, he has successfully completed January Center. He did also participate in the REACH program previously in Hartford, and also previously successfully completed Open Hearth in Hartford. He does have work experience while on supervision, including Wendy's, Trader Joe's Warehouse, 7-Eleven, BJ's, Shake Shack, and Teriyaki Madness. Most recently, he was reportedly scheduled to begin the CTPSB group. Before he was on supervision, he was participating in individual therapy at CRT. He is currently compliant on the Connecticut SO registry. He meets while in the facility with a mental health worker once every other week at Osborne Correctional. He is medication compliant. He would like, if possible, to go to a halfway house in Hartford. He, I know, is hoping in the future to utilize the REACH program once again. My client is hoping to obtain a position in a bakery, but is open to any sort of opportunities that are offered for jobs. He's also open to any treatment being recommended, including doing the CTPSB program and also getting back to individual therapy. And lastly, he is, I know, hoping to obtain his driver's license in the future. I'm asking that you would consider re-paroling my client prior to his EOS date later this year. As we noted, he really is somewhat limited on the support that he has in the community. He did, unfortunately, as I stated, lose his mom, who was his biggest support, and he will very much much need assistance with housing while in the community. Parole, I think, could certainly be of assistance to him in getting back on his feet, just to get some sort of, housing assistance, because later this year he EOSs and he won't have any supervision. So I know that he could certainly benefit from the services Parole provides. Thank you.
Thank you. Just gonna take a moment and then I'll announce my recommendation. So I've listened to today's hearing and I've reviewed all the evidence as well stated before. With that, I do just want to note on the records that this is Mr. Ellison's third violation on supervision. He was only out in the community for 18 days between his last re-release and remand to custody. And as Officer DeBryler stated on the record, the behavior is the same as his last violation. So the behavior hasn't changed for Mr. Ellison, his behavior. So with that, Mr. Ellison, I am going to recommend that your parole be revoked and that you have no new re-parole date. That's an approximate 10-month period of confinement as a sanction. In the event the board does decide to lessen my recommendation, I'm going to recommend the following conditions: a mental health treatment, enhanced internet and device monitoring, no contact with minors, problem sexual behavior treatment, restriction on and halfway house placement. So what happens next, Mr. Ellison, is that my recommendation is going to go to the board next week on April 23rd. On that day, the board can only do two things. They can lessen my recommendation if they choose to do so. And if for any reason they would want to, or that's it, or they can adopt the recommendation, which means that you'll stay until your end of special parole sentence. So you'll be notified with their decision about a week or so after that hearing date with what they've decided, okay?
Okay.
Colby, if you want to call our office on that day, either myself or one of the secretaries can let you know what the decision was.
Okay. And you said it was the 23rd next week? Or
Yes,
22nd?
that's right. The 23rd, the Thursday. Mhm.
Okay.
So this does conclude the revocation hearing for Colby Ellison, inmate number 419801. Good luck to Mr. Ellison. Thank you, Officer DeButler.
Thank you. Good luck.
Thank you.
Thank you, everyone.
Yeah.
Wow, a full revocation. What a pleasant surprise. But look, it has to go to the board for final review. So let's first go there and see if they agree.
Good morning, I'm Warrant Examiner Chiselle. Today is Thursday, April 23rd, 2026. The rest of the statements for the record.
Mike Holt.
Eileen Keys.
Panel Member Rodriguez.
This is the final revocation date for Colby Ellison, inmate number 419801. I recommend revoking no new re-parole date, which is an approximate 10-month sanction with the following condition. Oh, sorry, no new re-parole date, so no conditions, which is an approximate 10-month sanction. Does the board accept or reject this recommendation?
Accept.
Regarding Colby Peter Ellison, 419801, I move to accept the hearing examiner's recommendations. Is there a second?
Second.
Those in favor signify by saying aye.
Aye.
Those opposed, no. The ayes have it. And the recommendation is accepted.
The final revocation date for Colby Ellison, inmate number 419801.
Wow, I can't believe it. You know, he had the board there for his favor. The empty suit, Aileen Keys, right? She's just like, she's she's really one of my least favorite parole board members. She's just an empty suit. She always sits there. Thank you for talking to me. Oh, thank you. Thank you so much. Thank you so much for talking to me. And the things that she says, oh my gosh. See, Mike Pohl, he is the worst. Like, he's an evil villain worse, in my opinion. You know, like, he has an agenda worse, though, but that in some ways makes him at least better because he has an agenda. At least there's something that he believes in. At least like there's a hill that he dies on, as much as I don't believe it. But it's always good to have two sides of a spectrum. Not that I'm saying what he does is good. I also, but I don't know. Aileen Keys she just seems to like have nothing, like no backbone, insight, feel like it's just the strangest. Anyways, and then you have Rodriguez on the right, who's pretty weak. Sometimes he says things that you say, oh wow, there's okay, like he has an opinion. But you know, still, if I guess you want any board to hope to get a rejection of the reviewer, it would have been this one. And even then, they didn't even think about it. They didn't talk about it. They said, you're done. They didn't even say, like, you know what, we should make sure he has supervision. He's done. Now he's finishing special parole 12/2 of 2026. So he's going to get out without any type of supervision. I'm not even sure if he will. I don't even know how long he needs to register. Again, so look at this. So in 2016, he gets like his first arrest, and then he's, I guess, what is it again? So I'm sorry guys, I'm so sorry. Let's do the final cases over here. Yeah, in April 2016, he was sentenced as a youthful offender. We'll pull it up again. We went through this information already, but it was 2016. He was sentenced as a youthful offender for looking at stuff. So he's been doing this for 10 years now. He was given 4 years probation, right? No prison. And the crime which he was convicted, not specific, but probation officer with the sex offender supervision unit was assigned to Ellison's case. The warrant. 4 months after sentencing, the probation officer takes his computer and his devices. He hands it over to him and he says, "Yeah, I've been looking at online, content." So they seize his laptops and they find on their images of girls 6 to 11. So he's caught after he's caught looking at CP, he's given probation and he's caught looking at CP again. Now, they don't what happens then is it revokes his probation and he gets 4 years jail, special parole 6, and he's released 3 years later on 12/3/2020. He does get another offense for failure to register. And then, but while he's out on parole, he gets 3 violations of his special parole, all with finding like where he's violating his parole. But now they finally fully revoke him. Now, in the last searches, again, because the PO officer never had the devices analyzed by a special company, this is just only visual stuff. Who knows what really is on the devices? We only know what the PO officers did, and the PO officers did a good job. Now, I think that maybe I make the argument that they should have had the devices analyzed. Why did they not have the devices analyzed? I don't know. I just don't know. I would love to talk to the PO officer and say, why did you not run these devices through a machine? Maybe because they said, well, I have enough to revoke him. I don't really want to go through the cost of doing it. I don't want to go through the headache of doing it. I'll just show up and say he violated his parole. I have enough to catch him. Maybe this guy, this Chomo, is smart enough, sophisticated enough to almost leave it like a smoke screen, like a red herring. Like, okay, yeah, I'm in these. At least they didn't catch my other stuff. But because I don't believe that he has the impulse control not to try to look at the other stuff. So all the devices that he has. But who knows? I'm just speculating. Either way, this person has no impulse control. He's going to be counting down the days until he gets out of prison, which is really just like 7 months. And he's going to get out without any supervision. So we're not going to see him again except for the news. And how long is it going to take for him to get caught? Now, he has no impulse control. He's not, as far as I can tell, clever. The question is, how long will it take for him to get busted again? I hope there are people watching him. This is why it's good to have, like, again, like the Gideons and the Alex Rosen fried pickles of the world to catch these monsters, to catch these roaches. I hope that the local police are keeping an eye on him. But this is a scary thing. All you have to do is just get some type of warrant to take his device. You know it's going to be there. It's going to be there day one. All this guy can think about is, when am I going to be free without supervision? And he's about to be free without supervision. I am so happy, though, that the parole board not, because supervision doesn't mean anything. Please. But the crazy thing is, yeah, he probably is a lowest 3FN on a static 9.9. And I think the biggest takeaway, I'm not just saying this, it's not rhetoric, but I believe that he would fall under in data as someone who didn't recidivate. Okay. Because these are technical violations. They're not felonies, they're not arrests, they're technical violations. And when those look at recidivism rate, they don't look at technical violations under that umbrella. And I know this because we've covered it before. We have covered hearings of people who have gotten revoked, but we'll go down the list of times that they've gotten revoked for, I'm talking about um, uh, driving drunk, but it was just a technical violation for whatever reason. I have no idea why, and things like that. And the defense attorney would actually say, well, "This is my client's first violation, but Sir Richard has a record, and we'll see 3 arrests." I don't, and that's arrests, and then it gets pled down and blah 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 blah, and it's a technical violation. And yeah, so there's always manipulation of data. This was just one of those, and this will be one of those cases. So if anyone ever tells you in a debate, well, sex offenders, they have the lowest rate of recidivism, there are a lot of answers that you can say. People say, oh, they haven't gotten caught. People, you say another one, it's all a manipulation of data. It's BS. They cannot control themselves. And you can reference these cases. Anyways, with that, I'll let you go.